Okay. Good afternoon, everybody, and welcome to today's class of legal reasoning. Today we'll be covering Mock 3, and we are going to try and cover the entire syllabus of Mock 3 today. I don't think it should be very tough because it's hardly maybe like 8 passages. So if we all focus and if we all work hard together, I'm sure we will be able to complete it. Okay. So the methodology of teaching, all of you know by now. I would request those who would like to participate to raise your hands. I will give everybody a fair chance. Whoever would like to participate, please feel free to do so. Uh, those who are interested, first I will give the chance to read out the passage, then explain the passage. After that, I will explain the passage if there's anything further left to explain. Then one by one, the questions will be also allocated to the students. Those who are answering, whether it's correct or wrong, after that I will be explaining. Okay, so this is how we will go ahead. It's a very immersive class. It's a very interactive class. Okay, we don't have a chat box and we don't keep everyone muted. So you can feel free to speak whenever you like. Without any further ado, let us begin and let us see how it goes. So first of all, since we are studying mock 3 today, let me share the screen with all of you. Okay, and after that, I will request you all, those who would like to read out the passage, those who would like to explain the passage, I would like you all to raise your hands, and accordingly we can continue. Okay, Hijab, you can please go ahead and read the passage. Remember, all of you will get a fair chance. Whoever wants to participate will get a fair chance. So please feel free, okay, to raise your hand. Yes, Hijab.
So sir, first I'll have to read the whole passage.
Yeah, it's better to read the passage
Okay, sir.
because then everyone can understand what we are talking about exactly.
Yes, sir. So it goes. Various eminent authors have stated the importance of cybersecurity in the era of digitalization. As the digitalization has taken place, the emerging need of cybersecurity is being witnessed. Digital transformation has also created a focus on privacy protection and greater compliance requirement. As cyber attacks have become more sophisticated and damaging, regulatory bodies have established more rigorous rules and guidelines to protect consumer data and personally identifiable information (PII). As a result, organizations must be mindful of compliance requirement and turn best in class certified products, processes and people to ensure a reasonable level of risk management.
Yes, go on.
Although India does not have option is covered by Information Technology Act of 2000, along with associated rules and regulations which deal with cyber security as well as cybercrime, it provides legal recognition to online transactions and contains measure for safeguarding electronic data such as making punishable offences of hacking, denial of self-service attacks, phishing, malware attacks, identity frauds, and electronic theft. To combat cyber crimes, the CBI has in place the following special units and structures as the Cyber Cell under the provisions of Information Technology Act of 2000. The court in India have also recognized cyber crime. Example, the Gujarat High Court in the case of Jagdeep Varun Vrujlal Dipani versus State of Gujarat to mean the offences are committed against individuals or groups of individuals with criminal motives to intentionally harm the reputation of victim or cause physical or mental harm or loss to the victim directly or indirectly using modern telecommunication networks such as internet networks including but not limited to chat rooms, emails, notice boards and groups, and mobile phones, Bluetooth, SMS, MMS, anything that is an offense under Indian Penal Code 1860. IPC is equally an offense if it is committed in cyberspace, such as defamation, cheating, criminal intimation, and obscenity. The Personal Data Protection Bill 2019 protects the private information from being shared with private parties with the individual's consent. It, however, grants the government power to receive data from the third party platform which are otherwise required to maintain privacy of the users for use by itself or its agencies.
Very good. Okay. So now again we have an example of a passage which is quite long, okay, but the questions attached to it are not very complicated because they are quite directly linked to the passage, okay. Now this new pattern of CLAT is such that you have to really increase your reading speed, okay, your speed reading, your comprehension abilities. Those are what matter the most, okay. The language itself of this paragraph is very simple. There is not some like very complicated, language which has been used in the passage, but you will have to read all of this within a span of 2 minutes, okay, as well as understand it, okay. Now, I think the passage is very clear. Hijab, would you like to explain a little more about the passage? What it's trying to say?
Okay, so in this passage, the author is basically drawing our focus towards the Information Technology Act of 2000. It's basically related to the cyber security, which most of us like are the most of the people are threatened like in that course. So it's talking about that India does not has a specific cyber security act, but the Information Technology Act is enough. It provide guidelines. It secures the users it secures the users that they have necessary steps that if anyone threatens them or if anyone does anything wrong to them, they can sue them, they can catch them, and then there are legal procedures for it.
Absolutely. Okay. And then finally, after all the facts that we have been given, we have got a few principles also, right? Principles are such that if anything is a crime in IPC, that is a crime in cyberspace also. So, for example, if I'm giving some kind of a threatening message to somebody in real life, like if you don't do this, I will kill you. That is what? That is called coercion. That is called, criminal intimidation. Various kinds of things. Same thing if I send an email and say I will kill you if you don't do this. That is equally a crime. Okay. So anything which is a crime in real life, it is also a crime in cyberspace. Okay. Now, for example, we will come to the cases in the form of questions. There you will see the various examples. Okay. Good, Eja. Now, coming to the first question, who would like to answer? Please raise your hand. Read the question, see the options, consider what you think is going to be the correct answer. And okay, Aishanya, go ahead.
The question says Namrata decides to sell her air conditioner on buy and sell, an online platform for sale and purchase of goods. However, instead of receiving the money into her account, the amount was instead deducted and credited to the buyer for the air conditioner. She approaches the police station, who file an FIR and demand the details of the buyer from buy and sell, which refuses to provide the information, citing the information is confidential as per the Personal Data Protection Bill 2019, and a case is filed against buy and sell for refusing to provide the data. Decide. I think the answer is C. The police are an agency of the government, and buy and sell is bound to give data as per the Personal Data Protection Bill 2019. So in the last paragraph of the passage, it said that the government can receive data from third-party platforms, or any agency of the government can receive data
Correct.
from third-party platforms. So that is why.
Correct. And so, since the police is agency of the government, suppose I went and suppose Namrata herself went. Namrata herself went and said, like, I have been cheated and all. Please give the money. Okay. Do you or please give the data and the information? Do you think the buy and sell is bound to give the information in the same case?
No.
No. And why is that?
Because buy and sell is not an agency. The police is an agency. Or we are not an agency.
We are not an agency.
Yeah.
Exactly. We are not an agency. Police is an agency. So they are not bound to give us the data, but certainly they are bound to give the government. Okay. Good, Aisha. Next. Who wants to answer? Please raise your hand. You can read the question, see the options, consider yourself, and everyone will get a fair chance. So whoever raises their hand, they will get a chance to answer. Okay, I'm giving you all some time. Read the question, see the options, and if you feel like you want to give the answer, please go ahead. Come on, I think all of you all should try. There's no kind of shame in answering or giving a right answer or wrong answer. If you don't try, then you will never succeed. If you try, you might succeed, you might fail. But if you don't try, you'll never succeed. See, we need to have a more participatory class than this, okay? So if I'm only going to give you all the answers, then might as well I only write the exam for you as well, isn't it? Yeah. Okay, I'll wait for a while. Let's give somebody a chance. So whoever wants to answer, please raise your hand. We'll wait. Yeah, tell me something. Is this really that complicated that none of you are answering, or is it that I don't know what's the reason. I don't think it's that complicated. So
I think the answer should be B.
who is this? Can you raise your hand? Who has spoken right now? Could you please inform me? Hmm. See, this kind of anonymous answers I don't want. You raise your hand and you answer. Okay. And definitely I will give chance to the same students who have answered before. But I would really like it if new students answered as well, right? So, okay. Mimansha, go ahead. And from next time, I really request the rest of you also to participate. See, I will not gain anything if you are answering, and neither will the other students gain, but you will certainly gain. So try and answer. Okay, fine. Mimansha will answer this one. Next one, Vikash will answer, and after that, we will see who else will answer. Aishanya and Hejab are of course there. The quite serious and regular participants. I want more and more people to become regular. Okay, fine. Mimansha, go ahead.
Yes, sir. So the question says Varun was an avid fan of Meet Me, a social media platform. One day he clicked on an advertisement for shoes, and soon he found advertisements for the exact same shoes on every other social media platform he visited, such as Message Me, his messaging service, Click Me, his photo sharing platform, and so forth. He feels his privacy has been violated as he never consented to Meet Me to share his information with these other two platforms, which incidentally are also owned by MeetMe, and files a case. Decide. I think the answer to this question is option A. MeetMe is guilty of sharing his information with other platforms owned by it without Varun's consent and guilty under Personal Data Protection Bill to 2019. And this can be inferred from the last passage, which says the same thing, the Personal Data Protection Bill 2019.
Okay, Mimansha, you are correct. Okay. Now, of course, the answer is A for the reason you have said. Okay. Meet Me is guilty of sharing his information
Yes,
without
sir.
Varun's consent because obviously, we see this many times. Like we click let's say we search for shoes, or we kind of tell our friend that, hey, I want to buy some shoes. And somehow the microphone is on or the search records are on, and everywhere you go, Facebook, Google, WhatsApp, Instagram, everywhere you will see ads of shoes, right? You all must have experienced this kind of thing. This is nothing but violation of data privacy. Okay. Okay, good. Mimansha, now Vikash, you answer the second one. I think that we have skipped. Vikash, are you there? Okay, I think Shaurya also had an answer. Shaurya, are you there?
Yes, sir.
Okay, go ahead, Shaurya.
Sir, I think the answer should be B.
Oh, okay, and why?
Sir, because Preeti lost her password, and so that's why. But I don't think so. I'm wrong. I think so.
Okay, never mind. You give the fourth answer. Okay, I'm leaving that for you. Second answer I will give. Okay, Aishanya, go ahead.
So I think the answer is C. Ankit is guilty because the law does not provide a carve out for ethical hacking. And one more reason, I think B is not the answer because he hacked into the email service provider's the company also. So I think there is a victim. The email service provider is a victim of whatever happened. And ethical hacking
Very good.
is still hacking. So obviously he is guilty.
Right. So all of you must have heard of Byju's, right? Byju's, the coaching institute, online coaching institute. Recently, they bought one company called White Hat for a few millions of dollars, maybe 300 million or something like this. And this is some GK for you, some current affairs for you as well. White Hat is what is the meaning of White Hat? White Hat means ethical hacker. Okay, a person who hacks for a good cause rather than a bad cause. Okay, one of the famous ethical hackers of India is called Ankit Fadia. Okay, he actually started the concept of ethical hacking in India. But the fact remains that hacking is hacking, whether it is ethical or unethical. That is why Ankit will be guilty. Okay.
But the reason behind hacking should also be considered, na?
No, but that's what I'm saying. Now, the law doesn't consider hacking whether it is ethical or unethical. Suppose that there was some kind of gold chain, okay, belonging to one lady. Okay, now you saw the robber take that chain and go inside that house and keep the chain inside his house. Now you went in middle of the night to that robber's house and you stole the chain from his house and returned it to the lady. Okay, do you think you have committed a crime? Have you
Yes,
committed
sir.
a crime or not?
Yes, sir.
Yes, sir.
You have. Does it matter that you had the very good intentions or very ethical intentions that, oh, I will return the chain to the lady from whom it was stolen? That's not your job. Are you the police? It's not your job. Similarly, over here, hacking, it's a crime. Hacking is the same as theft, right? If you want to do something, why don't you report it to cyber security cell? They will do the hacking. They will do the information gathering. That's their job. It's like vigilante justice, isn't it? Okay, that's the
Yes,
reason.
sir.
That's the reason. Okay, okay, good. Now, next fourth question. Who wants to answer? And really, come on, everyone, don't feel shy. Participate, yeah. Like no one is going to eat you up if you give a wrong answer. It really doesn't matter. Fourth one, I think it is Shaurya's, right? Fourth one is Shaurya's, and fifth one already. I'm going to ask you all to raise your hand. Whoever wants to answer. Fifth one, whoever wants to answer, please raise your hand already. Fourth one, Shaurya, please be ready with the answer. Okay, fifth one will be Hijab. Shaurya, whenever you're ready, please answer fourth question.
Sir, the answer should be C, the cyber cell.
Why?
Sir, because Shanaya's social media account was hacked and used by someone else. So basically, it's a hacking case, and sir, basically Shanaya's ID is used by someone else, and the other can use her account in a bad manner also. So it should be legally treated. Means under
So, but
police.
can you tell me from the passage where in the passage itself you can find it mentioned that this has to be done. It has to be given to the cyber cell.
Sorry, sir, I came late. That's why I couldn't read the whole paragraph. Sorry.
Okay, no problem. There is a line over here. To combat cyber crimes, the CBI has put in place the special units and structures such as cyber cell. So now clearly, as you can see over here, social media account has been hacked. That is what? It is a cyber crime, very clearly. That's why it will be cyber. Okay. Next. Last one, Hijab. Go ahead.
Yes,
yeah,
sir.
that
Ravina broke up with Ramesh because he was mean to her. In order to take revenge, Ramesh shared some of the intimate pictures of Ravina through a messaging app with the entire friend circle. Ravina filed a case. Decide. So I think the answer should be B. Ramesh is guilty of harming Ravina's reputation and causing mental harm to her because it's clearly mentioned in the passage. mm, that any thing, the last, I guess it's in the fifth paragraph, anything that is an offense under Indian Penal Code 1860 is equally an offense if it is committed in cyberspace.
Yeah. So don't you think this will form like defamation, criminal intimidation, obscenity, all of these things?
Yes, sir.
But
Yes, sir.
there's also the case of Jaideep Gujral Depani versus Gujarat,
Hmm.
which
Yes,
says
sir.
that offenses that are committed against individuals or group of individuals, criminal motive to intentionally harm the reputation or loss of reputation using the modern technology,
Yes, sir.
that is called cybercrime. Okay.
Hmm.
And definitely anything which is a cyber crime is a crime under IPC also. Therefore, yes, certainly, um, Ramesh is guilty for harming Ravina's reputation and causing mental harm. These are like, for example, defamation, obscenity, etc. Okay.
Hmm.
Of
Yes,
course,
sir.
answer A and C are not correct because it says not guilty. Answer D, although it says that he is guilty in IPC, but he is not guilty in cyber space. Therefore, he is not guilty, which is again the not the correct answer. Okay.
So I
Now,
had a doubt. So could you
yeah,
tell about the Gujarat High Court versus Jaideep Gujral Depani case?
right. Now, in this case, uh, why we have mentioned about this case? We have mentioned about this case because there is no particular law with relation to cybercrime. So, if I say that, let's say, like, if I say that, somebody, I tell somebody that, hey, you borrowed from me 100 rupees yesterday, you have to give me back. So that person says, hey, I never borrowed from you any money. What's the proof? So I say, okay, although I don't have any direct proof, like I don't have a video of that I gave you money, or I don't have a written from you that I gave you money, still my friend was with me. So my friend will confirm that being a witness. Okay. Similarly, the 100 rupees which I gave you, okay, I know the serial number of that money. So if you check your wallet, you will find that note is in your wallet with the same serial number. Okay. So these are called circumstantial evidences. Okay. It's an indirect way of proving something which cannot be proved directly. Similarly, the cyber crime has not been defined under Indian law. What is cyber crime? According to Indian law, we don't know because there is no cyber crime act. So we look for circumstantial evidences, like for example, Information Technology Act. Inside the Information Technology Act, a lot of the cyber security as well as the cyber crimes have been covered. Okay, but not directly. Okay. Similarly, the court has also given a judgment defining what is cyber crime according to the Gujarat High Court in the case of Jaideep Rujlal Depani versus State of India. That is why this case is relevant. If tomorrow the kind of parliament comes with a law which clearly defines what is cybercrime, what is this, what is that, and everything, this case will become not so relevant. Okay. But for the time being, the only definition of crime is found under this particular case, which says that the offenses that are committed against individuals or group of individuals, a criminal motive to intentionally harm the reputation of the victim or cause physical or mental harm or loss to the victim by using technological methods, right? So same way as I said, if I tell a person that I will kill you, that is a normal method of intimidation or causing a mental harm, isn't it? But if I send a message or an email saying the same thing, it is a cybercrime, right? Same way, like in this case, this guy, he circulated the sensitive pictures of this girl, right? if he had kind of spoken it out amongst his friends or told something or shared a physical photo like we used to have earlier, like those physical photos, that would have been a crime. But now, since he has done it in a digital manner, it is a cybercrime. Okay? I hope it's clear.
Yes, sir. Thank you.
Fine. Now, next passage. Who wants to read it and explain it? Please raise your hand. Very sad crowd. Come on. Be a little more participative. I mean, you're not here to watch a movie, right? You're here to learn something. I mean, if I just read out everything, explain everything, read out the questions, explain every question, that what's the fun in that, right? Then you might as well just be watching the video which has been uploaded on the app. You can go and watch all the videos on the app. Why are you bothering coming at a particular time at 1:30 p.m., sitting in the class in a live lecture? That's to participate. Otherwise, you can just watch the YouTube, isn't it? So I don't understand why you all are not participating. If you all need time, read the passage yourself, no problem. But do participate. Okay, come on. Who wants to read out? Why? No one wants to even explain the passage. Let me do one thing. Let me give you all some time to read it. And then after that, hopefully somebody will raise their hand, because it doesn't make sense to continue a class like this. Okay, if nobody raises their hand for next 5 minutes, we'll just end the class, because I don't want to do a movie over here. It's not a kind of a monologue that I keep talking and you keep listening. Okay, especially when
Excuse
it's a
me,
kind
sir.
of yeah, hijab.
So I and Ashanya are not every time like raising hands, because it will be then like just we two are
Exactly,
answering.
exactly.
Yeah, we want to give other
I,
people also chance. That's why we're not, both of us, we're not raising hands that much.
and I can completely understand with both of you that like even I want to give other people chance. Like if I have to have a class with two people, then I won't have a free class where the people can join. Right? There's no point in having a free class for others to join, because others are just coming to become spectators or to create trouble, to create nuisance. So that's not the reason. So anyway, since we have promised that we will have a certain number of free lectures, we will continue with that. But after that, we will go back to our entire old methods where, people can more freely participate. So it's all right. Hijab and Aishanya, why don't you continue with the rest of the class? We will continue as we normally do. If others don't want to participate, that's upon them. Anyway, there are only 3, 4 more free classes. And then we can anyway, carry on with our own enrolled classes, right? Okay, fine, good. Anshuman and Sharan. Um, Fine, since I saw Anshuman first, Anshuman, you can read out the passage and explain. And Sharan, you can answer the first question. Okay, go ahead. Yeah, go ahead, Anshuman.
The hearing of matter concerning petition filed by State of Kerala contesting the centre's move to assign to Adani Group the functioning of Thiruvananthapuram Airport. This was appealed to the Kerala High Court order, which did not allow the writ filed by the state as maintainable. This refusal to entertain the writ by High Court was due to the fact that the matter concerned the relation between centre and the state. Therefore, it may only be taken up to the apex court under the Article 131 of the Constitution of India, and not under Article 226 as the present case. The High Court refuses to entertain the state's argument that there was other parties apart from the center, such as Airport Authority of India, and that the matter was one of the policy of the center. The state argued before the Supreme Court that there is a precedent such as a 1970 judgment in the state of Bihar versus Union of India 1977 ruling, in the case of state of Rajasthan versus Union of India and also till 2006 judgment in Tasi Delak Gaming Solution Limited versus State of Karnataka to suggest that when private parties are involved in center state dispute, then those cases Article 131 cannot be applied. Basically, sir, Article 131 connected with the मतलब कि I can speak Hindi, sir, because I'm not.
Yeah, no problem. No problem. Feel free.
So whenever there is dispute between center and state, and so we can approach court under Article 131 and 226. 131 we can approach Supreme Court, and 226 we can approach High Court. So what the state argument is that ki approach High Court since there is other private parties are also involved, like Adani Group and pata nahi kya kya. So that's why this is whole. I cannot see another para here.
That's all. Okay, good. What's your
Sir,
name?
am I correct?
Yeah, you are right. What's your name?
Sir, my name is Sakshi. It's my brother's ID. So
Yeah.
he also
Okay,
knows.
Sakshi. Okay, good. Fine. Okay, now this is a passage concerning constitutional law. Okay, the first passage, the first paragraph says that there was a petition or a case, you can say, filed by the state of Kerala, means like the government, okay, of Kerala, the chief minister and the minister of Kerala, which was contesting the center's move to assign to Adani Group the function of Trivandrum Airport. Now, every airport is run by either the state government or some private agency. Now, the central government wanted to take away the charge of the running of airports from the state government and give it to Adani, which is a private company. Okay. Now, obviously, the state government was not happy about it because state generates a lot of revenue from the running of airport. Right. Now, they approached High Court. High Court said that no, this is a matter which is a dispute between the center and the state. Okay, dispute between center and state is under Article 131 to be heard by Supreme Court only, not by any High Court, not by any district court. That's why they have said that you please approach the Supreme Court. You have come before the wrong forum. That's why we have rejected your claim. Okay, now various arguments which were placed in this case have been mentioned in the passage, which, as you all know, Sakshi has just pointed out. Now, let us move on to the questions. So, one by one, let us answer the questions. Okay. So, first question, who wants to answer? Please raise your hand once again. Okay, Tanay, go ahead.
Sir, in my opinion, option B is the correct one because it is clearly written that Article 131 is not applicable, and that was the reason why High Court dismissed the case.
So that is one.
Okay, and the second one, the first one, I mean option A. The core reason of the disagreement was state should have been given the project because they had more experience while operating all these things in Kochi and in Kerala. And that is why, and Adani Group has no experience according to the Tiruvananthapuram. Give me a second, sir. Yeah. So state of Kerala was stating that Kochi that Adani had no experience. That is why they wanted it to be given to them.
Is there any line from passage which you can point out and say this is the reason for saying that option A is correct?
No, sir. I am saying option D is correct. Both
B means B for Bombay.
No, sir. D Delhi. Option D.
So D Delhi is saying A and C, na?
Yeah.
So I'm asking you. I think you're a bit confused. What are you saying exactly?
I am saying that option D is correct. D Delhi is correct. Okay.
Right.
Option A. Why option? Now let me come to the option A and C, which are correct. Okay.
Yeah.
So option A, actually the question asks what is the core of the disagreement, why there was a disagreement. So the state should have been granted the project because state, the only reason why state filed the case was to somehow get the charge of the thing which was happening over there. And option C was the High Court dismissed it because of Article 131.
Correct.
They could not hear the cases.
Correct. Now I'm asking you,
Yeah.
is there any sentence from the passage which justifies option A as being correct, which I asked you already? Same question.
Yes, sir. Yes, sir. There is the line. There is a line. Give me a second. I will show you. Yeah, sir. In the last paragraph, option A. Why option A is correct? I am telling you. In the last paragraph, the state also complained that they were in direct competition with the Adani Group. With her,
Basically, state is saying that we have got a lot of experience
yeah,
in
that is what.
running an airport, and Adani has no experience. Then why are you
Yeah.
giving Adani? It's
Yeah.
similar to the case of the Rafale jets, okay, where like Anil Ambani's firm had been given a huge contract while it had no prior experience in aviation, right? So it hints towards a bias, right? Okay. Now, second question. Who wants to answer? Raise your hand. Okay. Mimansha, go ahead.
The question says, why did the High Court dismiss the matter? I think the correct answer is option D. All three reasons are correct, and this can be inferred from the passage, the second para. This refusal to entertain the writ by the High Court was due to the fact that the matter concerns the relation between the state and the center, and therefore it may only be taken up by the apex court under Article 131 of the Constitution of India,
Right.
and not
This,
Article 2. So this is the line.
yeah, very good. This is like very, very clearly written. As I already mentioned, 131 says that only between center and state disputes, only the Supreme Court can decide. Right? That's the reason. Good. Next, fourth one. Sorry, third one. Okay. Sakshi, go ahead.
Which of the following would be correct in the context of Article 131 from the above article? Option A is correct. Only Supreme Court can deal with the matter under Article 131. B is incorrect because for High Court it is Article 226, and C have confusion. What it says. Sir, A is definitely correct. I have some confusion with C.
No, so only A is correct because there's nothing else mentioned in the passage, right? So how can you assume that A or C is correct or anything? Outside knowledge is not allowed. So as far as the passage is concerned, only A is mentioned. That's why only A is correct. Okay. Next, who is the private party in the above article? Okay, Shaurya, go ahead.
Adani.
Adani is a private. This is, I think, a very, very plain and simple question, right? Last question, number 5. Who wants to answer? Okay. Anyone? Tanay, go ahead.
Sir, it is clearly mentioned in the passage. Option C is the right answer because they operate several airports in Kerala, and which was the reason why they were saying that they were more experienced than the Adani Group.
Right. Again, it links up to the same thing as we discussed before, right? That due to prior experience, they have a better, kind of CV in a way you can say, right, for running the airport. Okay, good. All of you good? This time, as you can see, the passage is very, very short. Last time you saw the passage was a bit longer when it came to that cyber crime passage and all. Medium one. Second one was a bit medium one. Third one is very, very small. Okay. So all kind of variety you will get in CLAT, and all kind of variety we are going to prepare you for. Okay. So first of all, who wants to read out the passage? Please raise your hand. Okay. Aishanya, read the passage and please explain it as well. Go ahead.
Online shop pay, a famous online marketplace, decided to list alcohol in its website for home delivery. After few days, government blacklisted the website and online shop services were not allowed on the ground that sale of alcohol online is in contradiction with the provision of public health and mortality. Online shop moved to the court against the suspension order under the Information Technology Act 2000. So here it says that an online marketplace had listed alcohol in its home delivery page. So after some days, the government had blacklisted the website, saying that it went against the provisions of public health and security. And then online Shopee moved to the court and they ordered petition against the government on the basis of Information Technology Act
Okay,
2000.
good. Good, Aisha. Now, see, the thing is, this passage is very, very short. Okay, there's hardly any information in it. Okay, now here, whether alcohol is allowed or not in the Indian law, not mentioned. Under what does the Information and Technology Act of the government say? Not mentioned. For what, on what ground the online shop has moved the Supreme Court also? Not mentioned. Okay, so sometimes it's actually better to have a bigger paragraph because there's more information there. Right now, when you see a small paragraph, you think, wow, so less to read. But that also means so less information. Now, the questions are definitely going to be much tougher. And there's also going to be a lot of information that you need to interpolate or assume or deduce or interpret, okay, from the limited amount of information in the passage that you have been given, okay. So since this is a different type of passage that we are doing, let us see the questions now, okay. So the first question, who wants to answer? I see a bunch of you all. Sharan, you have not answered before. Go ahead. Sharan, you can go ahead.
Sir, can you hear me? Hello?
Yeah.
Okay.
Yeah.
First question. An intermediary has been defined under Section 2, Subclause W of the IT Act as any person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record. Will online shop will qualify as an intermediary? No, because it's a website. No, because it was selling the alcohol. Yes, because it's an online marketplace. Yes, because it's providing a home delivery. Sir, I'll go with option C, sir, because it is acting as a vendor. It is just acting as that one medium which is like the intermediary, which actually like it satisfies that one principle of the passage, which tells that any service. It provides any service with respect to that record. The record is selling the this thing. Selling the drinks. I mean,
and another thing, on behalf of another person. On behalf of another person. Right. So even if you see like Swiggy and all these companies, they deliver food on behalf of the restaurant, isn't it? The food is prepared by somebody else and there's somebody else who will eat that food. Only in between the food is taken from that place and given to that place. That is called intermediary. Okay, what we say in Hindi as dalal. Okay, middle person. Okay, that is called intermediary. Okay, in a formal language. Obviously,
Sir?
Okay, online shop is an intermediary. Yeah.
Sir, can't we go with A? Means ki, in principle, it is written as any person. So, website is not a person. So, can't we go with
Good
A?
question. Good question. Now, see, there was a previous question also, which we had the Arco Polo Hospital, in which there was a robot which was conducting surgeries, and in that the question had said that person, whether a person includes a robot or a non-human person, that is debatable. Okay, for that matter, the government has declared dolphins, dolphins, as non-human persons. So dolphins are also persons according to law. Okay, similarly, it's very unclear whether robots are persons or not. In this case, you have to see, that's why I said in a shorter passage, the level of interpretation required from you is greater. Okay, the question is not asking very particularly whether, it's a person or a website or this or that. They are trying to test on the word intermediary. in the case of the robot, the main focus was on the word person. Is a robot, is a non-living thing a person? Here, they are not so concerned with that person word, living or non-living thing. Here, they are more concerned with the intermediary concept. So when you are solving a question, you have to see what is the examiner trying to ask you. Okay, like for example, if it was an English passage, okay, the question would ask you to find out the grammatical mistakes from this passage. There are probably going to be certain number of grammatical mistakes in any passage, right, that you find. But if it is an English question, if it is an English passage, they will ask you to find the grammatical mistake. In the legal passage, they don't want to bother with that. The question they're trying to ask you something else. And if you start answering that, sir, over here, there's a grammatical error, there might be, but that's not relevant right now. Understood? So your question about person, that's very good and that's very appropriate. But it could have simply said over here, any kind of person, instead of any person, they could have anything or person who on behalf of another thing or person receives. Because ultimately behind the website, there is a person. Behind Amazon.com, there's Jeff Bezos. Behind Microsoft, there's Bill Gates. Behind Apple, there's Tim Cook and Steve Jobs. Right? So the person is definitely there and your question is definitely valid. But you have to see what is the examiner trying to ask. The examiner is trying to ask whether an online shop is an intermediary or not. Whether it's a person or not is a question which comes afterwards. It's a relevant question, but it's a question that is less relevant than whether it's an intermediary or not. Right? This is why.
Yes.
If this question was the same as that Arco Polo robot question, I would say that person is the most important thing here. So try and like sometimes what we do, no, sometimes we confuse ourselves. It's very obviously the question is trying to ask about intermediary, but sometimes we confuse ourselves and say, oh, but ye to person hai, nahi, ye to website hai. That is my job to confuse you. That's why I've given the option A. No, but it is a website, right? So if you fall into my trap, then you will certainly fall into the CLAT's trap as well. Okay, because CLAT also really loves giving you like false answers which seem real. Okay. Next. Who wants to answer? Aishanya, go ahead.
Online shop claimed that it is only an intermediary and was not selling the alcohol. Section 79 of the IT Act is a safe harbor provision which grants conditional immunity subject to reasonable restrictions to intermediaries from liability for third-party acts. Whether the safe harbor principle can be pleaded by online shop. I think the answer is C. No, because the immunity is conditional. Because now we need to stick to the passage, and we don't know the conditions of the immunity, and we don't have to apply our own brain. So, and obviously it fell under the provision of public health and morality. Alcohol did fell under it. So I think the answer will be C.
Yeah. So now, again, this kind of question, since the passage is so short, we don't know what are those conditions. And like you said correctly, since we don't know, we don't have to apply our own brain. Okay. So the safest answer over here is C. No, because the immunity is conditional. Whether the safe harbor principle can be pleaded by online shop, honestly speaking, no one can say for sure. Okay, because it has not been mentioned. If you want to know under law, yes, there are certain conditions of public morality, decency, and you need to conduct more kind of background checks rather than simply like, you know, okay, I have seen that the alcohol is good or bad or something like that. Okay. Now, because the information is not clearly available, we have to choose the safest option. Safest option is no, because the immunity is conditional. What are those conditions? We don't know, and we don't have to know. Okay.
Can you please explain a bit, sir?
This kind of a question that we have in this passage, it is one where the passage is very small, unlike the first passage where all the information was provided. So a lot of this information you have to kind of interpolate. Interpolate means you have to kind of gather on your own. Okay. And you have to take a lot of judgment calls here. You have to take a lot of like decisions based on your own understanding and based on, you know, kind of your ability to, you know, answer those questions which the information is there and leave those questions where the information is not there. Now, in this passage, what information has been given to you? There has been an information given to you that immunity is provided according to certain conditions, right? Is it or is it not? Immunity is provided according to certain conditions. Okay. Now, those conditions are not mentioned. Okay. Now, that they are there or not. So now, when I say that there is this immunity available according to certain conditions, okay, and I say, will you qualify for that immunity? You are going to say, sir, how do I know? It is not mentioned. So when you don't know something and you have to say yes or no, you will have to say no. Okay. So let us assume like this. Let us say that a person can get certain benefits if they are scoring above 90% in their exam. Okay, then they will get a 50% discount. Okay, you will get half price if you get above 95% in your exam. Okay, now a particular student has joined. Have they used that particular discount? Can you say yes or no? Certainly you cannot say yes. Okay, because that discount is according to certain conditions, and it has not been specified that those conditions have been met. So obviously you cannot say that that student has got that particular discount. Otherwise it would have been mentioned in the passage, right? So
basically we will go to the no. Okay.
We will go to the no, because until and unless.
So, but there's a none of
Yeah.
the above also. So what about that? Like none of the above.
Because it has been mentioned conditional immunity. Okay. If it had not been mentioned, then it would have been none of the above. Okay. Then I can't say for sure. But it has been mentioned that there are certain conditions. And it has clearly been, clearly there's an omission over here that the conditions have not been mentioned. That is why it will be no. Otherwise, you would go to the none of the above. If you would say there is immunity subject to reasonable restrictions, then you could say, yeah, it's a none of the above, because on what ground that immunity will be provided, whether it is conditional, not conditional, it is not mentioned. But the moment you say it is conditional immunity, will he get that immunity? Obviously not. Otherwise, you would have mentioned those conditions. You would have mentioned if he's meeting those conditions or not, right?
Yes, sir.
Yeah, that is the reason. Okay. That's why in these short passages, be even more careful. In the longer passage, you don't have to apply much brain. You have to just see and answer. But in the short passages, you have to kind of think about it. Okay. Now, third one. Go ahead, Ajab.
So the question is, as per the rules, consumption of alcohol is permissible for anyone above the age of 18. Further, online Shopee claims that it has followed the intermediary rules, which provide due diligence and only delivers to those who provide ID card for age verification. So I think the answer should be B. No, cross verification of age is just not sufficient to qualify as due diligence, because what I think is that not enough information is given in the passage that about this. So the safest answer, I think it should be B.
Just do one thing. Read this line over here. What it says. It says that you cannot
After
sell
a few
alcohol
days,
online. You cannot sell alcohol online. It's as simple as that. Now you say, but I'm checking the age, I'm doing everything. Like initially when lockdown started, then completely home delivery of food and all was banned. Now suppose you say that, I kind of made sure that all the mask is being worn and hand sanitizer is there and temperature check is there, and then only I'm delivering food. Is it okay?
no, so once it's said it's not allowed, it's not allowed.
Means it's not allowed. Doesn't
Yes,
matter
sir.
how much precaution you take.
Precautions you're
Right.
taking.
The answer should be
Yes,
D.
sir.
Simple. Yeah. Okay.
So it should
Good.
be B.
Answer is, yeah. Cross verification of age is not sufficient. Okay, because Just because you did that doesn't mean that you are then allowed to sell. That's not sufficient. You have to go ahead with a complete ban. Okay. Okay. Next, fourth one. Who wants to answer? Dell. That's Shaurya, I guess, right? Okay. Shristi, go ahead. Or who is it? Who is Anshuman Singh? Who are you? Okay.
Hello.
Yeah. Yeah. Go ahead. Anshuman.
Simultaneously, alcohol companies have filed a petition against ban, stating that it violates the fundamental right to trade and business as provided under Article 19(1)(g)(1), which provide all citizens of the country the right to practice any profession, occupation, business, or trade of their choice, subject to certain reasonable restrictions, as laid down under Article 19(6)(2), which include public health and morality. Whether the petition of alcohol company will be maintainable. So answer is surely no to no only option. Option C is correct, because government banned these companies, stating that it is against public health and morality, which is given in
Correct.
Article 19(6)(2). So C is clearly correct.
Absolutely. Very good. That's the correct answer. Very simple, very correct. Okay, good. Next. Who wants to answer? Mimansha, go ahead.
The question says, as per Section 79 of the IT Act, an intermediary will be liable if it has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful act. While the hearing of the case was going on, one of the consumer of online Shopee who has purchased a wine of Super Strong brand from online shop died, and post-mortem report confirmed the death was due to the alcohol poisoning, and the sample of the purchased wine matched with that Super Strong brand which he had purchased from online shop. Who will be liable if a case is filed? The answer to this question is C. Both Super Strong and online shop will be liable. Super Strong will be liable because they are selling adulterated alcohol, and online shop will be liable because they are aiding the sale and not observing due diligence.
Sir,
Okay.
sir, I have a doubt in this question.
Yeah.
Sir, I agree that online shop will be held liable because they were not in norms with the given principle of the passage. But how is
Right.
Super Strong be held liable because of adulteration, sir? Because it was his who the consumers because it
So
was the consumer's
I
fault,
also
right?
have a I also have a doubt here. According to me, like the manufacturer, you can sue the manufacturer if the product goes wrong. But in various cases, it's not. If the seller, you can't just there was some snail case. In that, we didn't sue the seller. We sue the manufacturer.
Yeah, so Super Strong is the manufacturer, na? Super Strong brand.
Yes, sir. That is right. But then online Shopee again.
Because it's saying no
What
intermediary.
if? Okay,
Because
sir.
it
Yes,
is
sir.
written in the passage that the sale of alcohol online is not is against
Ha,
the provision of
prohibited.
public law. That
And
is
if you
why.
see
Yeah.
question number 5, starting line says, as per section 79 of IT Act, intermediary will be liable if it has conspired or abetted or aided or induced. So don't you think by selling that spurious alcohol, it has aided? Right.
Yes,
If
sir. That is right. But what if the online app wouldn't be an intermediary? Wouldn't have been an intermediary?
if
Then
it would
can
not have
we?
been an intermediary,
Yes, sir.
then it
Yes,
would not
sir.
have been liable, obviously, because
Okay,
only
sir. Yes, sir.
intermediaries are liable. So, but
Hmm.
since you already know it is an
So,
intermediary,
so
as
then
per
in
the
the
first,
snail case that we did,
yeah,
in that one we didn't sue the shopkeeper.
right. Because in
We
that
were
one,
Yes, sir.
this
Hmm.
point was not there. the first point, what is here in section 5, question 5, an intermediary will be liable if it has aided the commission of an unlawful act. Right.
Okay, sir.
This sentence has been given over here. This sentence had not been given over there, that the shopkeeper will also be liable. Shopkeeper is an intermediary. Intermediary means middleman or middle person. Right.
Yes, sir.
Between the manufacturer and the consumer,
Yes,
there is a
sir.
middle person, that is the intermediary. Okay. Now here very clearly it has said that intermediary will be liable. Okay. This is about cyberspace. Now the law over there in that snail case did not hold the intermediary liable. So that is why the shopkeeper
Yes,
was
sir.
liable in that case. Over here it has
So,
clearly
so
been
this
mentioned.
intermediary case only applies to the cyberspace.
Not necessarily, but it applies in this particular passage. It definitely applies to cyberspace. Whether it applies
Okay,
or
sir.
not to real life, that's a different issue. We are not
Yes, sir,
discussing
because
that.
we don't have to apply anything.
Right.
Yeah.
Whether it applies outside the cyberspace or not, we are not concerned right now. Yeah, as far
Yes,
as you all are, as far as you as law students, you know, because I have taught you that in the snail case, like, it is liability of the manufacturer and not of the seller and all, right? But of course, there have been different cases in which the seller has also been held liable, in which the intermediary also has been liable in the non cyberspace matters. So those are different issues, right? Right now, we have to see in the passage, they are talking about cyberspace. In cyberspace, they are saying that the intermediary is equally liable along with manufacturer. That's why Super Strong will also be liable, online shop will also be liable.
Okay,
Right?
sir. Okay, sir. Thank you,
Good.
sir.
Yes, sir.
Keep
Thank you, sir.
asking questions. Keep asking questions. If you don't ask questions, it doesn't mean that you know everything. It means that you did not understand anything. That's why you don't have a questions. You are afraid to ask because you will reveal how little you know. Yeah. So if you ask questions, it means that you are at least showing this much I have understood, this much I have not understood. If you don't ask questions, it means I have not understood anything. That's why I'm shy in asking questions. Okay. So good. Now, who wants to read out and explain the next passage? Hijab, go ahead.
So, in a state XYZ, rape is a punishable offense. Under a section of IPC, a man is said to commit rape who has sexual intercourse with a woman against her will, without her consent, with her consent, when at the time of giving such consent, by reason of unsoundness of mind or intoxication, or the administration by him personally or through any superfine or wholesome substance. She is unable to understand the nature and the consequence of the act, with or without consent, when she is under 16 years of age. Sexual intercourse by a man with his wife, and the wife not being under 15 years of age, is not a rape. When two or more violators rape a single
Sound ಕಮ್ಮಿ
victim,
ಕೊಡಪ್ಪ.
it is
Sound ಕಮ್ಮಿ.
Go ahead.
It is called gang rape. A person can also be convicted of murder if the act is done with the intention of causing bodily injury, is likely to cause the death of a person to whom he harms, is caused or cause such bodily injury which is sufficient to cause death in ordinary course of time. Besides, citizens of this state is conferred with several fundamental rights, one of which provides protection against arrest and detention. No person can be arrested without being informed on the grounds for such arrest, nor shall be denied right to consult or to be defended by a legal practitioner of his choice. Also, Article 161 of the Constitution has a provision of mercy petition which grants the President and the Governor power to pardon the sentence of death in all cases. So this passage talks about a state XYZ in which rape is a punishable offense. It describes certain criteria under the section of IPC, under which a man is said to commit rape. And in the last few lines, the author is trying to draw our focus on some of the fundamental rights which have been granted to the citizens of XYZ, like uh, Article 161, then protection against arrest and detention. So yeah, and lastly, he talks about Article 161 of the Constitution as a provision of mercy petition, which grants President and the Governor power to pardon the sentence of death in all cases. Yes, sir.
Right. Okay, good. Well done, Hijab. Now, now see what I've written here. There are like a lot of different things. One is the offense of rape, along with different aspects of rape. Okay. Apart from that, there is also some amount of like mention about like power of president to pardon and things like this. Even this power of president to pardon and impeachment of president and all of these constitutional provisions, they are very important for you from a legal GK point of view as well, because in the sample paper they had asked this question, like which article of Indian Constitution allows for the impeachment of president. They can even ask
Article 61.
yeah. Similarly, they can ask you what is the power for pardon. That's 161. Okay, so different questions. Fine. Now, I have mostly quoted the law here. So you saw in the first question, it was a long passage with, it was kind of an essay. It was kind of a person's opinion or an editorial. Okay. In the second one, it was a very concise problem-based question. Third one, it is simply law, plain and simple law. Law has been taken, simplified a little bit and written over here. So first I will explain to you what is the law, and second I will explain to you my opinion of that law. Okay. Now, in a state XYZ, that is India. Okay. Rape is a punishable offense, definitely. Under section of IPC, a man is said to commit rape who has sexual intercourse with woman. This is my first problem with the law. Why a man is said to commit rape who has sexual intercourse with woman? Why not a person is said to commit rape who has sexual intercourse with another person? Because we have heard of cases of male rape. Okay, there are a lot of different, there are transgenders, there are people of like LGBTQ community, all of these things, okay, who are consistently harassed. And this law is a very kind of a archaic, very old-fashioned, very like illogical kind of a law that there is only man, there is only woman. Man will rape a woman, that is rape. Okay, no. Okay, now against her will, definitely. Without her consent, definitely. With her consent, but in a way that that consent doesn't amount to consent. Like for example, if someone provides a lot of alcohol or some drugs or some kind of what is called as roofies. Okay, which basically are called date rape drugs. So like if that particular drug is put inside the drink, then that person becomes unconscious, and then the person kind of rapes that person. So that is another form. Okay, with or without consent, whether so consent is essential. Consent is key when the woman is like over 16 years of age. Okay, you need to get a consent from that woman. If there is no consent, that is rape. But if the woman is below 16 years of age, whether she consents or whether she doesn't consent, it doesn't matter. Okay, if the man is adult and the woman is below 16 years of age, that is rape, whether the girl said yes or no. Can somebody tell me why it's like this?
Because being underage means that you aren't that mature to decide your consent or not.
Right. So the reason is that when you are under 16 years
So, and what if the man is also a minor?
That is an interesting question. I will tell you afterwards. Now, I'll come to that. Okay. Now, when you are of a certain age, like 16 years, in some cases it is 14 years, in some cases it is 18 years, you are considered child. Okay. Child doesn't have competence to contract. Like if you look at Contract Act, any contract made with a child, with a minor, okay, it's not valid. It is at best it is voidable. If it is not void ab initio. Okay, there was a famous case of Damodar Das where some money was advanced to a minor on his guarantee that was held not valid because he was not knowing what he is doing. Similarly, in criminal law, you find any child who is below 7 years commits a crime, that is not a crime. Even if a child kills someone below 7 years of age, that is not a crime. Okay. Now, under the law of POXO, Prevention of Child Sexual Offences Act, POXO, right? What happens is that not 16, but rather 18. Any woman under 18, okay, or any child who is under age of 18, might be like boy or girl, who is sexually harassed, that is known as sexual abuse, okay, if not rape. And now regarding this question of if the man is also below 18 or not, well, strictly according to law, it's not strictly considered as rape, but normally what you find is that even if the man is below 18, still it is considered rape. Okay, let me give you an example. Okay, not with relation to when the girl is under 16, but when the guy is under 16. If you look at the Nirbhaya case, okay, one of them was a delinquent. Delinquent means under 18. Yet he was tried, yet he was punished just as a delinquent under the Delinquency Act, not under the IPC, right? But even if he was under 18, still he was found guilty of rape. Okay, why? Because the law wants to protect the victim, no matter what. And in this case, the woman is the victim. If a man is below 18, that should not be an excuse for that man to escape the justice, right? This is why
But
the
sir,
law
in Nirbhaya case, the man who was below 18 was not killed.
yeah, he
I
was
think.
not killed, but he was held guilty
Yeah.
under the Juvenile Act,
Yeah.
right?
Yeah.
So you mean that person wasn't hanged?
No, the juvenile guy wasn't hanged. He was not hanged. Although he was held, guilty, he was tried under Juvenile Act
He
instead of.
moved out of the jail also, I think. Now he's
Yeah.
out
So,
of the jail.
but the act, what he did was, it was like, it shows that he was mature enough to
This is why I'm saying that the
get
law tries
punishment.
to balance the victim and the this thing. Now, if the law said that any man below 18 cannot rape, right? Like what you were saying earlier, if he's below 18, will it still be called rape? Yeah, at least the law says yes, it will be called rape. Okay, he will be held guilty, he will be punished. Now, will he face the same punishment as a major, a person above 18? No. Okay, and
No.
especially with regard to Nirbhaya case, why? Because he was like literally 17 and a half. So this is where, you should treat him as a 18-year-old. But what happens in cases where child...
Sir, also because it wasn't just rape, it was like murder and in a very cruel way.
Exactly.
Yes, sir.
So in
And
this case,
also-
I feel that this particular juvenile should have been treated as an adult and he should have received the same punishment as adult. But Juvenile Justice Act doesn't allow for death penalty. Of how can you kill a minor? How can you hang someone who's below 18? That's what the law.
Sir, but also there's this provision which tells that if a person, like if there's a person below the age of 18, or if we can take it as a, like what, from between 12 to 18, sir. Let us assume that his age is between 12 to 18, and if he can know the act, what is he doing, that wrong act which he's knowing, if he knows the nature and the consequences of that act, then he could be, he could be tried also, right?
So what do you think happened right now?
That is what happened.
Yeah.
Okay, cool. Okay,
He got tried. No, he got called guilty. He just wasn't hanged because he was not a major. And the act doesn't allow you to give death penalty to a minor.
Cool, sir. Got it.
But he did understand the nature of his act. He did understand what he was doing. That is why he was tried. That is why he was found guilty. That is why he was punished. He just wasn't hanged because he was not a major. Okay. Understood? Clear? No, not clear. Next, sexual intercourse by a man with his wife. This is the biggest problem in the law, I feel. The sexual intercourse by a man with his wife, the wife not being under 15 years of age is not rape. Why do you think this law has been made?
Because marital rape exists, and even if a person is a husband or a wife, they don't get the right to rape just because they are married.
No, but this law is giving the right to rape. Na? This law is giving a
Yes,
marital.
sir, so that's a fault in the law.
And why you think this exists? This clause exists?
So because in the patriarchal Indian society, like when the constitution was made at that time, a husband had power over his wife. So I think that is why this.
Because wife is the property of her
Property
husband.
of husband.
Isn't
Yes.
she? The
Yes.
wife is the property of husband. That is why the husband can do whatever he likes with his wife. If he wants to have sex with her, he can have sex with her. Her consent doesn't matter. right? Because she's like a, like your car. Whenever you want to drive your car, you can drive it. Hmm? And it's the same thing with adultery, which has now become decriminalized. Adultery, if a man had, kind of an affair with a married woman, then the criminal wasn't the married woman. The criminal was the man who had an affair with her, because the offense was against the married man. He was like, "How dare you take my property?" It's like stealing someone's property. How dare you steal my wife? How dare you steal my property? So therefore you must pay me, because the crime you have done is against me. Not that the wife has done a crime by adultery. You got the point? Did you understand how these laws have come in? What was inside the mind
Yes,
of
sir.
these lawmakers?
Yes,
That
sir.
he has stolen my property. That is why he has to pay me. Okay.
So this
Same
law
way over here.
actually exists. Like there is no law for marital rape in the Indian Constitution.
Yeah, exactly. This is the I've written the law over here. Sexual intercourse by a man with his wife. That means they understood that there is something which could be called marital rape. There is something that the wife might not want to have sex, right? So let us do one thing. Let us make a special clause in the law which says that whenever the wife doesn't want to have sex, it doesn't matter. So they have gone and written this in the law that there is nothing called marital rape. When it's marital, how can it be
So
rape?
it's not changed yet. Like it still
No,
exists.
still like,
But so we also have provisions in domestic violence, right?
yeah, yeah. So
So a wife can complain in complaint of marital rape in under provisions of
but
domestic
marital rape is
violence.
not a crime, Baba. What will she go and say? He raped me when I didn't want to have sex. What will they say? IPC says
Sir,
you
so
can do.
if the wife complains, it may go under domestic violence, but it won't go under rape. Is that
Yeah.
what the law
If she if
says?
she if she says
Okay, sir.
if she says he slapped me, then it's domestic violence. But if she says he had sex with me against my will, that's totally legal.
So
Sir,
that's
but
not domestic
sir,
violence,
but
and that is also domestic violence, sir.
yes, sir,
No,
because it's a
according to
kind of
law,
a
it's not.
violence, no?
According to law, it's not.
Sir, and it is written
Ma'am,
that
can you
under
please be a
15
bit
years of
low?
age.
If she's under 15, yeah, then it's a crime. But that is because of this, like 15, 16. If it's without consent, because consent doesn't matter below a certain age. It's
Sir,
rape.
but now the law has been amended. The age has been increased to 18 or 21. So, sir, now what if
See,
the girl is
different
like,
different places, the age is differently mentioned. In IPC, you have 15 in one case, 16 in one case. In POXO, you have 18. In Contract Act, you have 18. Child is defined under certain places like POXO under 14. Okay, so different laws contain different ages. It's usually in the age group of 14 to 18. Okay. Now, anyway, moving on. When two or more violators rape a single victim, it is gang rape, like we saw in Nirbhaya. A person can also be convicted of murder if the. So now we are moving to different topic. Okay, a person can also be convicted of murder if the act is done with the intention of causing bodily injury, as is likely to cause the death of the person to whom the harm is caused or bodily injury, which is sufficient to cause death in ordinary course. Like for example, if I slap someone and they die, I can't be held guilty of murder because I didn't have intention to kill them, and normally no one would die from a slap. But suppose that person has a very injured neck. I didn't know about it. I slapped them. They died. It's a different thing in tort that's called eggshell skull and crumbling skull rule. We won't get into those things. But under IPC, what it's simply saying is that if you had the intention, mens rea, to kill someone or to harm someone, and that happened, you will be guilty of that act. Okay. Next. Besides, citizen of this state is conferred with several fundamental rights, one of which provides protection against arrest and detention. No person can be arrested without being informed of grounds of such arrest, or shall be denied, a lawyer. Okay. And finally, there is a mercy petition which can be granted. A pardon can be granted by the president. Okay. So, first of all, intention to cause death can lead to, that is the essential ingredient for death. Second of all, if you are being arrested, you have to be informed the reasons, right? So you must have seen in those TV shows, when somebody is being arrested, they are told like, you have the right to remain silent. Those are known as the Miranda rights. Okay, under the US law, Miranda rights. Basically, even in India, when you are arresting someone, you have to say why. You can't just arrest anyone without any reason. Okay, you have to give them the reason. And they have the right to legal aid. You are allowed to appoint a lawyer. If you can't afford a lawyer will be provided to you. Okay. And finally, there is a power of pardon with the president, as we all know. Okay. So let us start with the questions. I think there are going to be 5 questions. So I'm going to ask 5 people, and one by one you all say. So number 1, hijab. Number 2, Tanay. Number 3, Anshuman. Number 4, Aishanya. Number 5, Shweta. Okay. Let's start. The rest
Neeru
of
was
you
a
I will
hard
answer.
Neeru was a hard-working professor with a busy schedule in weekdays. On weekends, he used to hang out with her male friends and drink liquor. One such night, Jignesh bought a few drinks, which he insisted on sharing with him. Later that night, Neeru was in an intoxicated state and engaged in sexual intercourse with a Jignesh with her consent. Next day, she realized what had happened and accused him of raping her. Jignesh, so the answer would be C. Did not rape her because he did not administer it personally. It is clearly mentioned in the question first that she was the one who insisted to take the drinks, and it is mentioned in the third point with her consent. When at the time of giving such a consent she was in a intoxicated state or anything. So from these 2 points we can draw an inference that she was the one who insisted him to intoxicate her, and now she can't just blame Jignesh for raping her.
Exactly. The answer will be, you can say, I think according to me, the answer will be A. Okay, because he did not rape her because she gave her consent. It is written over here that Jignesh brought few drinks which she insisted on sharing with him. She's like, hey, can we drink, can we have, some drinks together and this and that. And then she had like sex with him. It's perfectly normal and perfectly natural. There's nothing wrong in that. But then she cannot accuse him of raping her because she herself has asked to get drunk. Right.
Sir,
Yeah.
sir, she consented to drink, not for intercourse. Na, so,
How do you know?
how she will be liable for?
How do you know? It says later that night, Neeru was in intoxicated state and engaged in sexual intercourse with her consent. It's written here, with her consent.
Okay, I got it.
Sir, but that consent was in the intoxicated state of mind, right?
Yeah, but it was voluntary, na?
Like, sir, even though if it is voluntary, that cannot be absolute, right? Like,
yeah, it can. It can. See, what happens is that intoxication has to be involuntary. Okay, it cannot be voluntary intoxication. Like, for example, under contract law, also you must have studied that there is no competence when it is like intoxication. So suppose I am like completely. So suppose you come over here and you offer me some chocolates. Okay. And I eat those chocolates, and you have mixed up some drugs in those chocolates. Now I become completely like intoxicated. After that, what happens is that you say, "Ki, sir, can you please sign a check and give me? I need some money. Can you give me 1 lakh rupees?" And I am so intoxicated that I'm like, "Yeah, no problem at all. I take out my checkbook. I give you the 1 lakh rupees, or even not even checkbook. I open my drawer. I take out the cash." Whatever cash I have, whatever gold I have, everything, I give it to you and you go away. Okay. Later on, I say that it was out of intoxication. Do you think that it's a good case or a bad case? Do you think it's a good case or a bad case? I'll tell you, it's a good case. You have gotten me intoxicated. Okay. So it is involuntary intoxication. I never wanted to drink. I never wanted to get intoxicated. I just wanted to eat a chocolate. Okay. Now, if you have taken advantage of me in that situation, that is not acceptable according to contract law. But suppose you came and I only said, hey, why don't you sit down? Let's have few drinks and all. I got very drunk and very high. And after that, I said, hey, you are my best friend. You are my brother. Let me give you some money. It's my choice. I want to give you a lot of money. So I took out all my gold and valuable and I gave you. Then is it okay or is it not okay? That time it's perfectly fine. So voluntary intoxication, I cannot myself get drunk and then say, hey, I was drunk. Why were you drunk? That's upon you. Same way over here, if a girl is having a
Sir,
drink,
but she didn't give consent before she was intoxicated.
but she did now. Well, that doesn't see. That's what I'm trying to explain you. Okay, there is no proof to say she was unable to understand the nature of her act. So many times it happens that people go to nightclubs, girls and guys and everyone in every city of India. People go to nightclubs, they get drunk, they go and they have sex. What's the big deal in that? But if every time the girl is going to say that, oh, I was drunk, so then nobody's going to drink before sex. You see, that's not the point. The point is she is unable to understand the nature and it is without her consent. You must understand there's a very big difference. If you're having a few drinks, you are feeling like having sex, you are having sex, you are not a minor, etc., etc., it's totally fine. So over here, I'm just explaining to you all, try to understand the law. This is not a matter of policy, because a lot of times what happens, even with me, what happened when I went to law school is, I started debating the law. But sir, the law should not be like this. The law should be like that. So the law is what the law is. Like, I feel the law should not be that a girl is a guy's property. Yeah, but that's the law. So we have to change it. We have to fight it. But when the question is given in the exam, we have to answer what is being asked from us. The law says that if a woman is intoxicated against her will, or if she's made to have sex against her will, then it is rape. Okay? Otherwise, it is not rape.
Sir, will is not mentioned in passage ki, against her will or...
Yes, sir, it wasn't given in the passage that intoxication should be against her will or with her will or anything like that.
No condition given.
I'm sorry, I didn't get you.
So by reason of unsoundness of mind or intoxication, it's not given that the girl should have the will to be intoxicated or not.
What is this? With
So that's for that's for rape. That's not for intoxication.
Okay, yeah, maybe since you all are students, I should have mentioned this fact that intoxication must be voluntary. It's my mistake. I should have mentioned it. I forgot that you all are like beginners. When we say the word intoxication, we mean involuntary intoxication. Means somebody has intoxicated you. Like when we say like roofies or date rape or chloroform or any of these kind of things. Okay, which is like not as per your own choice. Okay, otherwise what's wrong in a girl having few drinks and having sex? Nothing wrong in that, right? But then you will say that is rape because she was intoxicated, right? Have you seen a case where a girl had a few drinks, then she had sex? Big deal. And she was totally fine with it the next day as well. Now this lady was not fine with it. That doesn't mean the guy is a rapist, because she voluntarily got drunk, she voluntarily had sex. There's no element of rape over here. I should have mentioned to you all, because you all are like children right now, that when we say intoxication, it means involuntary intoxication. Like I explained earlier with the example of giving away all my money, right? Voluntary and involuntary. Is it clear now?
So the case of the movie Pink is not applied here. So because in that case the girls had. Okay, sir. Okay, sir.
What happened? The girls had consented.
So the girl had like she willingly intoxicated herself, like she got drunk with the guys, and then one of the guys raped the girl, and in the end the girl won the case. Like it was said that no means no, so it doesn't apply over here because she was willingly intoxicated.
Arey Baba, in that case you used one sentence. You said they willingly had drinks both together.
Yes, sir. Yes, sir.
Same case here. They willingly had drinks both together. Okay.
Yes, sir. Yes,
the
sir.
girl came to the guy's house later at night. In both cases, same, right?
Yes,
in
sir.
In your case of Pink, what happened? The guy raped her in her sleep, right?
Yes, sir.
And in this case?
Oh, sir, yeah, she gave consent. Okay, sir.
Now, next day she wakes up and she's like, I was drunk. Arey, bhai, you were drunk. You bought your own drinks. Like, what's the big deal? You asked to get drunk. You wanted to have sex. And next day you said, no, you have raped me. right? There has to be a balance in the law also, right? I think that the law is 90% against women. I feel the law is 90% against women, but 10% it is against men also. Like in this case, I feel if the woman got drunk on her own because she wanted to, she had sex on her own because she wanted to, then she can't blame the guy for it. Okay?
So
Do you
what?
agree?
So what
Do
is
you
the
agree
answer
with that?
then? Yes, sir. Yes, sir.
The answer is A. Did not rape her because
Yes,
she
sir.
gave her. I think in the book there's a typo. It has been given as B. So if you are ever referring to your books, please change that answer and make it A. Okay.
Okay, sir.
It is not rape because she gave her consent, and it is not intoxication because it was voluntary. Please remember, intoxication is only for involuntary intoxication. Okay, not for you yourself got drunk and you yourself are blaming someone else. Doesn't work like that. Okay. Next. Whose turn was it?
It was my turn, sir. Tanay.
Go ahead.
Yes, sir.
Sir, can you hear me?
Yeah, go ahead.
Okay, sir. So the answer is option B because he's her husband. And after doing some calculation, I have come to the conclusion that she is just 1 day older than 16-year-old. Okay, so it doesn't matter if she was ready or not. As you said, wife is the property of husband, so it is completely okay. He kind of raped her or whatever, had sex with her. So it was completely okay. It was not a crime. But however, sir, I would like to ask a question
Yeah.
related to this thing. Sir, every time I have seen written on walls that if a girl is below 18 years old, she cannot legally be a wife of someone else's. So raping is a secondary thing. I think a wife below the age of 15 will be an illegal thing, no, sir?
Okay. See, couple of things you have to remember here. First of
Sure,
all,
sir.
that this law was made in, I think, 1860, if I'm not wrong, the IPC. Okay. The law you are referring to is Hindu Marriage Act that was made in 1955. Okay. And various other marriage laws, those are more recent. In past days, you ask your like great grandparents, they will tell you that they got married at the age of 10 and 12 and 15. Okay, so it was very common practice. It was completely legal at that point of time. This law has not been amended since then. Now,
Yes, sir.
second of all, why haven't they amended the law and said 15 to 18, 18 to 16 and this and that? Okay, similarly, in Hindu Marriage Act, why it is said that a marriage with a minor is voidable, not void? Because law wants to maintain the sanctity of marriage. Okay. Now your question is actually pertaining to the marriage laws, not to the rape laws. Marriage laws, why this rape law is saying 15 and all when you can't marry below 18 is because they allow marriage below 18. They allow marriage of any age person also. But
Sir.
why they allow? Because they want to maintain the sanctity of marriage. You know, in India, the sad reality is that if a 12-year-old girl is getting married, she has a very hard life in front of her. But if that after that marriage, if like because it is held illegal and this and that, and it is dissolved, the husband is put in jail, the wife is divorced. Can you imagine the life of a 12-year-old divorcee woman in India?
It would be
No,
really
sir.
hard, sir. It would be
Right.
pathetic.
That's why they say it is voidable. If the woman is okay with that, she can continue. If woman is not okay with that, she can divorce. Okay.
Sir.
That is why over here you have this thing of 15 years and 16 years of age. Okay.
Sir,
Thank
sir,
you, sir.
excuse me, sir. Sir, can you please tell about the difference of voidable and void?
See, this will go into another class altogether. Okay. I'm trying to complete a mock over here, but very basically, I'll tell you void and voidable differences. Void means void ab initio, means it is starting, it is void, like a contract with a minor. Okay, or
Yes, sir.
a person who is incompetent to contract. Like for example, a person who is insane. Okay, due to insanity. If you go and make a contract with an insane person, do you think it is a valid contract? Of course not.
No, sir.
It's an invalid contract. Voidable contract are those made under undue influence, coercion, etc., fraud, etc. Suppose I put a gun on your head and I said that you sign away all your property, you sell me all your property for 5 lakh rupees. Okay, maybe the property was worth 6 or 7 lakhs. Okay, when I went home, then you said that okay, now I'm not okay for selling my 6 or 7 lakhs property for simply 5 lakh rupees. So you will say the contract is void. Okay,
Yes, sir.
or you may say that okay, it was for 6-7 lakhs. Anyway, now because of coronavirus, no one is going to buy my property. 5 lakhs is actually good price only. So let it be. So the contract is valid. Okay, that is known as voidable. Voidable means it can be valid, it can be void at the option of the person against whom the injustice has been done. In a very simple manner, I will say. It's like tossing a coin in the air. It could be heads, it could be tails. That is voidable. It could be valid, it could be void. Have you heard of Schrodinger's cat? I doubt. Schrodinger's cat is a concept in physics where you imagine there to be a cat inside a box, and until you open the box, you can't tell whether the cat is alive or it is dead. Obviously, right? That is for Schrodinger's cat. Voidable contract is the same. Till the person decides that I want to hold the contract valid or I want to hold the contract void, you can't say. It is voidable. Okay? Understood?
Yes, sir.
Okay. Next. You should say thank you after you get the answer from the teacher. Yeah, just a lesson
Thank
in
you, sir.
Okay. Next.
Sorry, sir. My mistake.
It is. No problem. Next. Whose turn was it?
Sir, my turn.
Go ahead.
4 men raped a girl using extensive force to engage in sexual activity with her without her consent. As a result of substantial injuries, she succumbed to death. Her family members accused them of murder. Did they murder her? Certainly, yes. Yes, their act caused her death. Yes, the bodily injury was sufficient to cause death in normal course of time. So, after reading the passage, I think D is more correct. So, option D is
Okay.
correct.
And why?
So, in passage, it is written somewhere. I can't see the passage.
Yeah.
In some last.
Well, here.
A person.
Right.
A person can. Yes, sir. There.
Very clear. I think this is a straightforward question. Answer is that D. Yes, the bodily injury was sufficient to cause. This is basically Nirbhaya case.
Yes.
Isn't it?
Yes, sir.
Okay. Next. It's a continuation of the previous question.
The 4 men were arrested after an FIR was lodged against them. In the custody, they were detained and were not allowed to meet or call anyone by police officers as a punishment of the brutal act that they had committed. They now want to claim their right to have an access to lawyer to defend them. Can they claim so? Sir, I think the answer will be D. Yes, because state has conferred. No, sir, I think the answer will be B. Yes, as a citizen of XYZ, they can seek protection against arrest and detention. D is also an answer, but B is more specific about it.
Yeah, because it has given an entire section number and this and that, and like it has just like very clearly they have given the answer because you can match it then to the particular passage, right? Okay. Next, question number 5.
Question number 5. The inhuman incident attracted the public uproar in the state. In the trial, the court laid guidelines to hang the 4 condemned men. The convicts tend to file a mercy petition. Can they do so? Sir, according to me, the answer is B. They can file a mercy petition, but it can be granted or rejected, as it is written in the Article 161, as mentioned in the passage. That okay. Thank you.
Yeah, well done. Okay. So yes, as Shweta mentioned, under 161, it is very clearly given in the passage that you can grant the mercy by the president. Okay. Good. Now.
Sir, so the answer will be B.
Sorry, the answer will be D. D for Delhi.
Okay, sir, but it can be granted or rejected.
That's not this thing, no? Why? Because here, see, it's B is not wrong, but that's not the question. It can be granted or obviously, if you're going to put a petition, that means if you ask your mom, can I have ice cream? Obviously, she can say yes or no. But my question is that why do you have the right to ask for ice cream in the first place? That is because citizens of the state are conferred with certain fundamental rights, one of which provides protection against arrest, etc. And also, that means another one, which provides for uh, right to pardon the pardon the death sentence. I think here it should not have been fundamentally, it should have been certain rights, because 161 is not a fundamental right. Fundamental
So
rights are
it's
from which
rejected or granted. That is none of our business. We just have to
that's
stick to
not,
the answer.
that is the right answer. That's not wrong, but because the passage is talking about the provision of constitution under which, like, you will say, can they do so? Yes. Why? How? You will say, sir, because it is written in the passage. I will say, in the
Okay,
passage
sir.
where it is
So we
written,
have to
then
give the
you will say,
reason.
yeah, then you will say, sir, in the passage it is written that the constitution allows. That's what the answer is.
Okay, sir.
Is
Thank
it
you,
written
sir.
in passage that it can be granted, rejected? हाँ, कर तो सकते हो, लेकिन हाँ भी हो
Yes.
सकता है, ना भी हो सकता है. कौन पूछ रहा है आपसे? हम पूछ रहे हैं क्यों और कहाँ लिखा है. आप कह रहे हो सर हाँ क्योंकि कॉन्स्टिट्यूशन में लिखा है, right?
Okay, sir. Thank you, sir.
No problem. Let's leave it for today. We have finished half the kind of mock. We'll do the next half in the other class. And more importantly, now for the next 15 minutes, I'm happy to take any questions. Okay. So anyone has any questions regarding legal reasoning, regarding any other subject, or even regarding any other topic, whether it is CLAT or not CLAT, you can ask me. Okay. So anyone has any questions, please feel
Yes,
free.
sir.
Yeah.
Sir, what should be ideal time? मतलब कि how long we can attempt legal reasoning in new pattern CLAT? Means
See.
I took 45 to 50 minutes, so it's lot.
Okay, see, let me tell you very clearly about time management. You have 150 questions, you have 120 minutes. First of all, you do your GK section, 40 questions in 10 minutes. You don't need more than 10 minutes to do 40 questions of GK. Okay, done. Now you have 110 minutes left and you have 110 questions also. So you take 1 minute for each question. Now this is across the board, okay? Because some students find legal tougher, some students find English tougher, some students find logical. I feel that all are the same. Apart from GK, all are the same, okay? So you should take 1 minute per question, okay? If it's a 5 questions paragraph, take 5 minutes. If it's a 4 questions paragraph, take 4 minutes. Also make sure to leave 5 minutes at the last for revision. Okay, 5 minutes at the last for revision. Okay, and one more 5 minutes for checking your CBT, because you are doing CBT for first time. It came as surprise to you कि अब CBT में mocks करना है. So 5 minutes you leave for revising your CBT, which you would have left for revising your OMR sheet otherwise. Okay, so now you have only 100 minutes and you have 110 questions. Okay, so you think accordingly. You have to take less than 1 minute for one question. The only way to do is this: learn speed reading and start answering intuitively. The problem is what we all do many times, we read the whole passage, like we have to write an essay on that passage. No, just read the passage once very briefly, then go on to the questions. From the questions, you go back to the passage. Like for example, you remember the passages we did. Right now, since we are practicing, we are reading the whole passage, we are explaining the whole passage, then we are reading each question, understanding it, explaining it, like that. No, when you are writing the exam, read passage very quickly within 1 minute, go to a question, see what's the question asking, go back to the answer. Let's say, for example, passage is saying that any sex with a person below 16 years is rape. Okay, now you go to the passage, not you go to the question says that Rita is a 12-year-old girl and she had sex with someone. Okay, is it a thing or not? Now you are thinking, okay, now let me check with the passage what it said. You go back to passage said 16 years, you're like, okay, no, then therefore yes, it is rape, done, like that. Okay, if you start reading the entire passage, understanding the entire passage, reading each and every question very carefully, you will never do it in 2 hours, let alone you will never do it in 4 hours also. Okay.
Yes, sir. Thank you.
So we have to be fast in legal reasoning.
You have to be very fast in all the subjects.
Oh.
All the subjects. And one more thing, remember, Do a bit of guesswork. I know everyone else will tell you that don't answer the question till you are perfectly sure this, that. If you toss a coin, 50% you will get this, 50% you will get that.
Yes, sir.
In a passage, in a question, let's say if you are sure the answer is yes, because two options will be yes, two options will be no. Let us say you are sure it is yes, but you don't know which one. Is it yes this, yes that? Don't leave it. Do it. That means you have a 1 in 4 chance of getting an answer correct in normal case. Okay, if you don't know anything, you will get 1 in 4. But if you know it is yes, you have a 1 in 2 chance, half a
Yes,
chance,
sir.
right? If you do 10 questions, normally if you leave 10 questions, you are going to lose 10 marks straight away. Okay, or let us say even 4 questions. Suppose you see 4 questions in a passage, you don't know the passage, you don't know the questions, you want to leave it. You leave it, you lose 4 marks. Let us say you don't know any of the answers, you are just doing blind guesswork and you will solve all the 4 questions. According to law of probability, you will get 1 right. Right, 1 out of 4. According to law of probability, you will get 1 right. So you will gain 1 mark. And you have not done 3, you have done 3 wrong, so you will lose 3 marks. Plus you will lose 0.25, 0.25, 0.25, so you lose 0.75. So total, you will lose 3.7 marks and you will gain 1 mark. So overall, your benefit will be 0.25 marks for having done a blind guesswork. Right?
Yes,
just according to law of probability. Now, if you actually know the answer is between A and B or between A and C, then your chances improve much more. Suppose you were doing 4, you get 2 correct, 2 wrong. So you lose 2 marks plus half a mark, and here you gain 2 marks. So your
Yes.
total gain has been 1.5 marks. Understood?
Yes, sir. Thank you, sir.
You have a lot to gain by trying. I am not saying that just go blindly to exam and take everything and come back. No, I am saying that you spent, let's say you spent 1 hour or 1.5 hour, and till now you have only completed like half the paper. You are anyway not going to NLS. Okay, so you might as well start doing some intelligent guesswork, not guesswork, intelligent guess. Okay, make sure you answer at least 140, 145 questions, because according to me, the cutoff is going to be quite high. Okay, this time. So between, between 5 marks, the whole game will be. Okay, so if you are going to leave 20 questions, if you are going to attempt only 130 questions, you already lost NLS, NALSA, and UGS. So there's no point after that. Okay, yeah. Next.
Sir,
what
my
should
question. Okay, sir. My question is with respect to AILET, sir. All India Law Entrance Test. Sir, what could be the good attempt in the quant section of AILET, sir? Because
Good
I've heard,
attempt.
like, there are 10 questions and there are 90 minutes test. So what could, like, because it's a very tough paper, right? I expect AILET to be very, very tough than CLAT. So, like, what could be a good number of questions to attend in AILET, sir? Because we can't give around, we can give around 15 to 20 minutes for math section. So, like, because it's going to be tough. So I always keep attending. I've seen mocks. Like, my highest attempt is 4 or 5 questions out of 10, sir. So I just wanted to know that.
See, that depends on your preparation level. That depends on your, some people do maths very quickly or QT very quickly and they struggle with English. They struggle with GK. Some people do GK and English very quickly, but they can't do maths. So it really depends on you. Okay, if it's a matter of like either I will do all 10 questions of maths or I will do all the other sections, then of course focus on the other sections, because a lot of time what happens is that when we are focused on one section, maybe we are able to do that section very properly, but then we miss out on everything else. If it is a matter of 10 marks, maybe if you are doing 5, it's okay to leave 5 as long as you are not leaving more than 5 in any other section. You got my point?
Yes, sir. Got it, sir. Got it, sir.
Yeah, my basic thing is don't waste time. Don't waste time. That's the most important. Okay. Next. There was someone else who was speaking at the same time. No? Okay. So nobody has any other questions? Great.
Sir,
Yeah.
sir, can you please say about the average number of questions to be attempted in CLAT? We should attempt in plat.
Yeah, that's what I just mentioned. You should attempt at least 140 to 145 questions.
140. Okay, sir.
Try and attempt all. Go in with the idea that I'm not going to leave even one question.
Okay.
Suppose that from your wallet you have bundle of 100 rupee notes, and out of your wallet falls on the road, and all the 100 rupee notes they go here and there. Are you going to pick up only 4 or 5, or are you going to pick up the whole bundle?
Whole bundle, sir.
Think of your flat paper like a bundle of 100 rupee notes. I will not even leave one.
Yes, sir. Yes, sir.
Next.
Thank you, sir.
Next. Okay, great. So that's all for today. In our next class, we are going to finish the second part of mock 3, passages 5, 6, 7, 8. It would be great, very helpful if you read those passages, if you kind of solved those papers, try and understood what is being asked from you, then it would be easier for us to all discuss in our next class. Okay. As I mentioned before, you all can message me, call me, send me on a Telegram, DM me anytime. I'm always available for you. Maybe I will not answer immediately, but I will certainly answer. Okay. I'm sure you can, see from your own experience, or if you have not previously contacted me, you can ask someone else also. Maybe I don't reply immediately, but I certainly reply. Okay. I want to make sure that each and every student who is asking me any question, personally, I'm replying to them. Okay. So that's the thing. Okay. Good luck to all of you for rest of your classes this week. And I will see you all again next week on Wednesday, same time, same place. Okay. Thanks a lot.
So much, sir.
Thank you, sir. Thank you for the class, sir.
Thank you, sir.
Very
Thank
much,
you,
sir.
sir.
Thank you, sir.